Thanks, Graham. We've received many questions from viewers about COVID's impact on custody, support, provincial jurisdiction of visitation, and the speculation about a potential spike in divorce rates due to self-isolation. Tanya Davies is a family lawyer specializing in divorce, and she joins us now. Tanya, I would say that these are very difficult times for those with the best of relationships, let alone those who are in the middle of an acrimonious custody battle or divorce. What are you hearing from your clients?
Good afternoon, Leanne. We're actually getting a lot of phone calls in relation to the access issue. Primary residence parents, unfortunately, are using the issue of COVID-19 to deny access to the access parent. And there are a lot of decisions, even though the proceedings of the Ontario Court of Justice are suspended, but emergency proceedings are still being heard. And we're getting quite a few precedents on the access issue. And what the courts are telling us is that you cannot really use a blanket policy to deny access simply because of COVID-19. If the access parent is not able or willing to follow all the safety measures that are being imposed and recommended by Health Canada, that's a good reason to suspend access. Anything else, if they're taking all the safety precautions, it's not a good reason to deny access. Basically, the courts are telling us don't even go to court to bring an emergency proceeding. And it's very good for children to be exposed and emotionally and psychologically supported by both parents, especially now.
So if one parent is concerned that the other parent isn't following protocols, then that's a legitimate complaint. But for the most part, custody is going ahead as per an agreement?
That is correct, or per court order that is in place. And whenever you bring an emergency motion, you actually need to bring forward concrete evidence, not he said, she said, as to why the access parent is not complying with safety precautions and how they're not doing it.
Well, this is also completely unprecedented. And of course, due to checks at the border over the past number of days, we've received questions from viewers wondering about, one parent in Gatineau, one in the Ottawa area. Have you been addressing any cases like that? What should we know?
So the rule of thumb, Leanne, is still the same. You should not be exercising access if you've been traveling, for example, if you've been diagnosed with COVID-19, if you're exhibiting symptoms. Obviously, all of this is common sense. However, at the checkpoint on the bridge from Ottawa to Gatineau, it's at the police officer's discretion, but what they're trying to do is limit non-essential travel. Examples of essential travel would be work reasons, for example, medical reasons, and humanitarian reasons. We can say that access, for example, would fall under the humanitarian reasons ground. But what parents need to do is make sure that they bring a copy of their court order, their separation agreement across the bridge with them to indicate to the police officer that it's not random, it's not made up, that it's actually in order for them to exercise access.
That is an amazing point. Now, so many people are dealing with job loss, and that may in fact affect support payments. What should those who are in a position of receiving support or paying support know?
So a lot of the recipients, when they receive support directly, not through the Family Responsibility Office, can contact the payer directly or through their lawyer and maybe negotiate something, especially when it comes to child support, because it's the right of the child and these are trying times. We still need to be supporting our children. So under those circumstances, when support is being received directly, there is a possibility or an opportunity to negotiate something directly, maybe to lower the payments. Through the Family Responsibility Office, all of them are working remotely, but support payments would still be enforced. However, of course, if the payer was laid off and there's truly zero income, that's a material change in circumstances. And in those cases, support can be suspended.
Good to know. Now, Tanya, all of this is speculative, but a lot of people have been talking about the fact that there's an expected spike in divorce rates after this period, this trying time of self-isolation, where we see the best of relationships and the worst of relationships. We see the best of character and the worst of character. It's not speculative for you. You've been looking at what's going on around the world. Tell us what you've learned.
Yes, I think unfortunately, Leanne, it's reality. If we look at China, for example, in certain areas where quarantine was lifted, the divorce rate just skyrocketed. And of course, it's only logical whenever people are confined in their residences all together, let's say parents, children, sometimes even grandparents. Normally, they would not be seeing one another so much throughout the day because they would go about their normal lives. They would be going shopping, maybe going to the gym, obviously going to work. But now they see a lot of one another. This creates conflict that is coupled with some financial problems whenever people are getting laid off. Financial stress and financial crisis obviously puts a lot of pressure on people, and this is when arguments start. So we are expecting for the divorce rate to increase for these reasons.
Well, as we've mentioned, so many people are going through so many difficult times, and people are having to work together and figure out solutions. What's your advice during this very unique, rare, unprecedented time of self-isolation?
My advice, Leanne, especially when it comes to parenting and access issues, and this is what the courts are telling us, that parents need to be flexible, they need to be reasonable, they need to work together to come up with proper resolution for the sake of the children to actually allow the access parent to exercise access. And the courts are also telling us that whenever things normalize, what's going to happen is that the primary residence parents' activity of denying access unreasonably would be raised in future court proceedings, and that factor would be used against them.
Thank you for joining us today, Tanya Davies, who specializes in divorce law. We appreciate your time. Graham.